My name is John Michael. I'll be presenting the cases to the board for their consideration today. This time, we would respectfully ask that everyone in attendance please silence your cell phones or tablets or any other electronic devices you have so that the board's meeting and hearings in particular will not be interrupted. In each of today's public hearings, the board will review the correspondence submitted in support of and opposition to each of the cases. The board also reviews correspondence and recommendations submitted by other government agencies, in some cases elected officials, and even the public as part of their preparation for the hearings. Staff presents the site plans, maps, photographs, and other documents that comprise the case record in today's hearings. And then at the conclusion of the staff presentation, the appellant will present his or her case to the Board of Zoning Appeals. After the appellant's presentation, the board would hear from any of those in attendance wishing to speak in support of the appeal. After the supporting speakers have participated, any opposition that is present will have the opportunity to present to the board as well. After the opposition presents its testimony, the appellant will have a period of time for rebuttal. Under BZA rules, the appellant has 10 minutes to make the desired presentation to the board if there's no opposition present. For contested cases, both sides have 15 minutes to present their desired testimony. It's important to note that that 15 minutes is collective. So if there are 4 or 5 people who want to speak in support of or opposition to a case, it's important to divvy up your time in advance as it is shared among the group. At the conclusion of each hearing, the board will deliberate and then vote on the case before them. The board is vested with the power to do so under the provisions of the Metro Zoning Code, and specifically Section 17.40.180. All the section numbers that we refer to today come from the Metropolitan Zoning Code, which applies to the entire jurisdiction of the metropolitan government and was put into effect through Metro Council action on January the 1st of 1998. I'll introduce the entire zoning code today and make it part of today's record. The Metro Code also requires a record of these proceedings. Because BZA meetings are recorded for Metro Channel 3, it is imperative that anyone addressing the board come forward and speak into the microphone. Introduce yourself by name and address, and then make the desired presentation to the board. The Metropolitan Code requires 4 members of our 7-member board in order to establish quorum. In the event that only 4 members are present for your hearing and the appeal fails to receive 4 affirmative votes, the appeal will be re-advertised for the next available public hearing. In the event that 5 or more members are present and the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to the Chancery Court within 60 days of the hearing date. Additionally, an aggrieved party may file for a motion for rehearing within 60 days of the original hearing date, pursuant to the terms of the BZA rules and regulations. After that time elapses, the board's decision becomes final and no further action can be taken. If appeal is granted, you are actually required to obtain the permit for which you applied. A permit must be obtained within 2 years for a board approval to remain valid. It should be noted that if any false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing before this board. Mr. Chairman, I would submit that all the cases have been filed in the proper order, all appellants have been notified by certified mail, and all legal notice requirements have been fulfilled on the cases that will come forward at the board today. Toward that end, I will make brief preliminary announcements, if I may, with regard to today's agenda.
Before we do that, is there something going on with our lights up here? They just keep on going.
I'll work with staff once we complete the preliminaries and see if we can get a little more light on the board.
Well, it's not, it's just going on and off. It's somewhat distracting, but proceed.
Case number 13, which appeared on an early iteration of our BZA docket, is a case that has been withdrawn and will not be heard by the board. Case number 2017-036, involving property at 402 South 11th Street, is still in its process with the Historic Zoning Commission and will be deferred to a later date accordingly. And then finally, case number 2017-084, involving property at 804 Montrose, still has some notice requirements to complete with regard to their signage, and therefore will be moved to the next docket, April the 20th, and be heard at that BZA hearing. With those 3 deferrals confirmed, we'd like to take a moment at the outset of our meetings to recognize elected officials who are present with us. And today there is the one and only Councilmember Sharon Hurt. Councilmember Hurt, we invite you, if you wish, to come address the board on the case of interest to you at this time. If you wish, you're welcome to wait if you want.
Council Lady at Large, Sharon Hurt. Welcome to the BZA. Please press the button, and as John, I don't know if John Michael said, there's no limit for council people, so we're always happy to have you here. I'm sure you can speak to whatever in a nice amount of time.
Well, thank you very, very much. I appreciate you all giving me the opportunity to stand before you or sit before you. I am here in support of Mrs. Billy Sanders of Sunshine Enterprises' appeal regarding permits for duplexes that she owns at 33rd and Albion. As you may know, the Codes Department issued short-term rental permits on both sides of her duplex at that location in 2016. Then, after investing in furnishing those duplexes and relying on the income, the Codes Department revoked the permits because of an error at the time of the issuance. On February 24th, 2017, an ordinance was presented and became effective that changed the definition of the short-term rental properties to a residential dwelling unit containing not more than 4 sleeping rooms that is used and or advertised only through an online marketplace for rent for transient occupancy by guests. Thus, under the new definition, she is in compliance and deserves to use both sides of the duplex. She is appealing that she's able to keep the permits for both sides or that they be reissued. In my opinion, her request should be honored. If for no other reason, it should be grandfathered in since she was granted the permits prior to everything else happened when she first began renting the property. She has done a research, spoken to her neighbors who have no problem, and the councilman of that district, Councilman Ed Kendall, also approves this appeal. So I humbly ask that you honor her request and grant her the permits as she has appealed. Thank you.
Commission members, any questions of Council Lady Hurt? Okay, seeing none, we also have a letter. You mentioned that the district councilperson, Ed Kendall,
Yes.
is in support of this. We also have a letter from Council Lady Erica Gilmore. It's also council at large, too, one of your colleagues, so she is also in support of this. And now we have bright lights. So, thank you.
Thank you.
Really bright lights. Be careful what you ask for.
The Board of Zoning Appeals utilizes a consent agenda with each of its meetings. One board member reviews the record for each case prior to the hearing and identifies the cases where appellants have met the criteria for their requested action. If the reviewing board member determines that testimony in the case would not really alter the material facts at issue in the case, then that case is recommended to the board for its approval. We'll enter into the record those cases that have been recommended, and if anyone is here in opposition to one of those cases, please signify by raising your hand and indicating as much so that we can remove the case from consent agenda and hear it in its regular order. Mr. Chairman, there are 5 cases recommended for consent agenda today, the first of which is case 2017-066 for the property located at 1910 and 1912 21st Avenue South, requesting a variance from certain sidewalk requirements. The second case recommended for consent agenda.
We asked for if there's anyone in
Oh, sorry, of
opposition.
course. Is there anyone here in opposition to case 2017-066? Seeing none, the second case so recommended is case number 2017-072, involving property at 6246 Fredman Road, requesting a variance from side setback requirements. Is there anyone here in opposition to case number 72? No opposition, I suppose. Very well. The next case recommended for consent agenda is case 2017-079, involving property at 814 West Trinity Lane, requesting variances from side and front setback requirements and height restrictions. Is there anyone here in opposition to case number 79? Seeing none, the next case recommended for the consent agenda is case number 2017-082, involving the property at 100 Rolling Mill Road, requesting variances from rear and side setback requirements. Is there anyone here in opposition to case number 82? Seeing none, the fifth and final case recommended for consent agenda is case 2017-083, involving the property at 622 Davidson Road, a request for a variance from side setback requirements. Is there anyone here in opposition to case number 83? Seeing none, Mr. Chairman, those 5 cases have been recommended, have no opposition present. We would solicit a motion from the board at this time.
Okay, I'd like to officially move those to the consent agenda. Is there a second?
Second.
Okay, motion's been properly made and properly seconded. Any discussion on the consent agenda? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Consent agenda passes unanimously.
For those members of our audience who are present on one of the cases that was just heard on consent agenda, you have been approved. You need not stay if you do not wish. You can see the Codes Department as early as tomorrow morning in order to pick up the permit for which you've applied. Have a good day. For those whose cases have not been resolved yet, we will begin the first hearing at this time. Mr. Chairman, the first case that the board will hear is case 2017-055. John Pirvasi is the appellant and owner of the property at 2414 Oakland Avenue. This is an item A appeal regarding the denial of an application for a short-term rental permit based upon prior operation before issuance of the permit. The zoning map shown here gives you a sense of the intersection in the R8 zoning district. The property shown here from its aerial view and then from its street view. Is there anyone here in opposition to this case? All right, seeing none, you'll have 10 minutes to make the desired presentation to the board. Certainly, we're happy to field any questions from the board since this technically is an item A appeal. Otherwise, we'll just allow the appellant to make his desired presentation.
Please identify yourself in your address for the record, and you can begin with your 10 minutes.
Thank you. My name is John Pavarsi. I am here representing my house at 2414 Oakland Avenue, corner of Oakland and Beechwood. I am appealing an abatement letter that was issued October 31st, 2016, to allow me to continue my application for a short-term owner-occupied permit. Through this process, I have tried to comply to the best of my ability, and I will conservatively say it's been difficult. There's been a lot of confusion on my part through information about what was required and what actually applied to me. I've had some confusion with mistaken and conflicting information received from other individuals in my neighborhood who, through last fall and a lot of the confusion with short-term rental had represented to me that we didn't need a permit because a permit was deemed unconstitutional and a lot of other issues. I've got a timeline that talks to that. I shouldn't have done that. I should have addressed it directly with my council member who was part of the group that drafted up the short-term rental, Berkeley Allen. So
before you get
Sure.
involved in your, briefing, this is an item A appeal,
Correct.
as you know, and so we're here to make a decision if the zoning administrator, Bill Herbert over there, erred in his decision. So when you talk about, this particular case, please address things that why the zoning administrator was wrong in revoking your permit.
Okay, I didn't have a permit revoked.
Okay.
I was never granted a permit.
Okay, well, not granting a permit
Okay.
then.
Okay, and that's where I'm going. I'm just trying to give some information. So I feel I'm an innocent offender. Actually, my wife and I, we never received the abatement letter that was sent out on the 31st. Had no clue that we were in violation of anything. And through last fall, we were talking and came to the decision, this short-term rental permit is a issue that is going on in Nashville. You can read about it in the Daily News or the Tennessean pretty much weekly. And so we said in January, let's just go ahead and get a permit. We're going to need one anyway. So on the 24th of January, I went down to the permit office, spoke with Clint there. That's the first time I ever found out that there was an abatement on my property, and I wasn't allowed to get a permit. I was instructed to appeal the abatement letter to the BZA in the March 6th meeting. At that point, Clint told me I was going to get information. It was going to be emailed to me from Codes Department as to what the procedure I need to follow. As of January 22nd, I emailed my council member Berkeley Allen requesting assistance, guidance, information, help as to how, knowing that she drafted this, what's the best way for me to go and do this? To this date, I've never received anything back from her. February 22nd, I contacted Metro Codes. I work downtown, so I drove and dropped by and said I was supposed to get some information. I've got a March 6th hearing. What's going on? I spoke with Debbie Lipsey over there, and through finding out information, found out that all of the communication was going to the wrong email address. My email address is my last name at gmail.com, and the email address entered that she had was gmai.com. So I never received any information. At that point, Debbie was kind enough to move the hearing to April 6th. Going through this process and not knowing, never receiving the notice, it doesn't seem right that we lost the right to apply for a permit as we never received it. Wasn't sent certified mail, as the hearing notice for appearing here was sent certified mail. We received it in good standing. We're an upstanding citizen in our community. We're not one of these places that's looking to be a party house. We have rented the house 4 times, right? We rent it and look to rent it when we were going out of town. Since we were told about this, we've stopped renting it. We've taken it down off the online advertising websites. It's a very high-end property. We very carefully screen renters. This is our family home, our primary residence, where my wife and daughter and I, live, 99% of the time. Just during the times of family travel, we look to make some income from our property.
So when you said that you found out in January on the 24th is when you went down and realized that I guess someone had reported that you had rented it before and there was an abatement letter. That's when you learned that. But at that point, from that point on, you didn't rent the property anymore.
Correct.
And so when was the last time you actually did rent the property?
It was over the New Year's weekend, January 1st.
Okay.
We rented it 4 times in the 7 months going up until January.
Okay. So you basically in this, your case is that, yes, you did rent it prior to getting a permit, and you explained why, and that's, you're not the first one to come and
Oh, I'm sure.
So we
I'm
understand
sure.
that. So basically, you're saying, yeah, you're kind of guilty as charged, but you did stop renting it. It's you're an owner-occupied. We get it. So you would like for us to not give you a year penalty and do something that's more reasonable. Is that what I hear?
That is. We
Okay.
didn't know we were in violation at the time when we were running it. If we would have known that, we never would have done it.
Right.
We're not serial offenders.
Okay.
We've had no complaints about the times we've rented it. There have been no police calls, no noise violations. We've spoken with our neighbors adjacent to us. I've got an email from one of my adjacent neighbors who supports us in getting this permit. The other neighbor doesn't have email. Very nice lady, Connie Doherty. She doesn't have any issues with us as well. Immediately, the one thing that I think is important is immediately when we found out what we were supposed to do, we've done that, right? When we found out that we weren't supposed to rent it anymore, we stopped renting it. We found out we're supposed to take it off advertising. We immediately took it down the next day. Again, I thank y'all for your time. We're going to stand by whatever y'all say, but I feel that I should have a fair share in being able to rent, as we're not.
Okay. So we appreciate you being here. Any questions for the applicant? Do you have anything else to add?
I do not, unless you want a copy of what I've gone through from a timeline, an email from my
Oh, yeah,
neighbor.
we'll take that. That's good.
Okay.
Mr. King, did you have a question?
I was going to, you got information from neighbors or something?
Yes. I've got an email from Eric Jolly, who is my adjacent neighbor at 2409 Belmont Boulevard. He's at the corner of Belmont and Beechwood. I'm at the corner of Oakland and Beechwood.
Yeah, please give us that for our case. And with nothing else, let's close the public hearing and start deliberation. So, as we get a lot of these cases, this is someone who said that they did not know that we had laws related to short-term rentals, and when they found out, they stopped advertising and rental, and it didn't sound like they had a lot of rentals anyway, just when they go out of town on occasion, so.
Mr. Chairman, if we may, on behalf of staff, an important point. There was discussion of the notice of violation. That, of course, is not what's technically being appealed at the BZA, merely the denial of the application. The notice of violation is the instrument used by the Property Standards Division for their cases in environmental court. So this particular case is tracking through court, but completely separate from that is the appeal with regard to the permit on the surface. I thought that was an important clarification.
Okay, well, while you're at it, so let's talk about this item A appeal. So the reason that they're appealing the denial of the permit. And the reason the permit was denied was because of what we normally hear from our zoning administrator. What do you have to add to this denial and why? And
It's my understanding from talking to staff that when staff checked to see if the property had been rented, they found that it had been rented prior without having a permit, and based upon the current iteration of the ordinance, we can't issue the permit.
Okay. So basically, they probably saw a posting or a listing online, and so that's why he got denied or made ineligible to get a permit.
Yeah, I mean, I appreciate all the arguments. I know that there's not a lot of clarity. I understand how the neighbors talk. To me, it's a case where, and especially not getting the letter of the 31st of October. I certainly understand that. But also, have full respect for all the folks that come here, especially owner-occupied homes where once they try to do the right thing, they stop doing the wrong thing, and then there's that length of time. I think it's a pretty classic case, and so I'm happy to make a motion that we find that the zoning administrator did not err in denying this permit because the home was rented prior to seeking a permit, but given the unique circumstances to this case, that the time between denial and today is sufficient penalty, and that this applicant would be eligible to apply for a permit tomorrow.
Okay.
And I will second that.
The motion has been made and properly seconded. Any discussion on this motion? Seeing none. All those in favor of the motion signify by saying aye. Aye. Opposed? Congratulations. So what we have said is tomorrow you have to go back to the codes department and apply for a short-term rental permit. You will be eligible for a owner-occupied short-term rental permit. So, but you still have to fill out all the paperwork and go through all the things. But what we basically said, since you were so forthright, and once you found out you were in violation of this law, you stopped renting and you pulled down any advertisement. So lesson to other people, that's one of the big things we're looking for. So if you get caught doing a short-term rental and you don't have a license, immediately stop renting. Don't keep on renting to the people that even booked in the future. Cancel those and comply with the law. So we hope you comply with the law in the future, and thank you for being here.
Absolutely. Thank you. I appreciate it.
Mr. Chairman, the next case to be presented to the board is case 2017-085, another short-term rental case involving property located at 1004 Waverly Avenue. This item A appeals a challenge to the denial of a short-term rental permit, the denial having been predicated on prior operation before the permit had been issued. Zoning map shows the approximate location of the HPR here on Waverly Avenue, just above Wedgwood. Aerial shows the house as constructed and a front view of the unit in question. Ms. Stevenson, if you would please come forward, introduce yourself by name and address. Members of the board, there was a supplemental bit to the file, basically just the printout screen grabs from the listing of the property demonstrating the reviews that had been the basis of denial. I'll pass those around so you can glance at those if need be, but other than that, the file is complete. Is there anyone here in opposition to this appeal? Seeing none, Ms. Stevenson, you'll have 10 minutes to make the desired presentation to the board.
Press the button, please.
Speak, sorry.
Yes, that's it.
My name is Carla Stevenson, and I am here to testify on my primary residence, 1004 Waverly Avenue, Nashville 37203. I also was denied a short-term rental permit. I also had some confusion around whether or not I needed a permit. Back in 2015, I contacted my accountant to understand, what taxes were involved, and they provided me a website, the Metro website. And I went to that website. I actually have I'm in HR, so I document everything. So I have a screenshot where I submitted a request for someone to contact me with questions with how to go about my primary residence on occasional weekends if I were traveling or something to that effect. I didn't get a response to that. Then on 3 different occasions, I contacted a phone number. Oops, wrong folder, that's why. I contacted the number on the website, 8615-862-8750, on January 6th, the 19th, and the 26th of January, and did not get a return call. At that point in time, I really didn't know what to do. I went next door, spoke to Dr. Gill, who's my neighbor who is attached to my property, talked to him about it. He had mentioned that there was a home across the street that was doing it, but he didn't know anything about it. I went ahead and started advertising then on Airbnb. I rented my home, I do believe, 10 times last year. I did receive a letter then in February of this year asking me to, cease the advertising on the website, which I did immediately. I came down to Metro Codes now that I had the information that I needed, where I needed to go, and spoke with a couple of people there. They provided me a document in which provided me all the things that I needed to obtain and bring down. So I took off work, came down a second time, sat with them, went through all that, and was then, I guess, denied the permit application at that point in time because I had rented prior to having a permit. And so I haven't rented my property either since then. I too am a good citizen and a respected professional here in the Metro Nashville area.
So since February, you haven't rented the property?
No, since I took it down, which was probably, I didn't know what to do. It was probably March the 3rd, 5th, something around there.
And did you cancel any reservations you had after
I
that?
have
How many was that?
3.
So we do have one letter in opposition from Christy Carr Klein, who seems to live nearby. And she talks about parking issues of the property and sounds like just in general against short-term rentals.
I don't know who that is.
It also, this letter kind of implies, it talks about other short-term rentals on the street, but it might imply that you own more than one home on this street. Do you have any other property?
No, this is my primary residence. I've lived there for...
So you don't have
Do
any
you
other?
own any other property or live in any other property?
No, I live at this property. I have 3 rental properties that I've had for, 7, 8 years.
And where are those?
Justin Court, Anderson Parkway, they're managed by a friend of mine. They're old. They're like 6-month long-term leases. They're not any kind of Airbnb. They're like 6-month rental.
So none of those are short-term rentals?
No. They have like 1-year leases, 6-month leases, and I can provide whatever documentation around those leases is needed.
Sorry, I think our attorney had something to...
There's one thing I need to bring to y'all's attention. This particular property, a warrant was filed in environmental court for renting and operating and/or advertising without a permit. Yesterday, in environmental court, an order was entered by the judge, a mandatory injunction that the violation cease, and it was reset for status to determine if they had come into compliance. So as we sit now, this case, there is a separate case on this property pending before the court.
What is the legal effect of the injunction as it relates to this board?
Well, there are two different issues. Before this board, you were determining whether or not she appealed the denial of a permit. So y'all are looking at whether or not the permit should have been denied. The environmental court judge will look at whether or not there was a violation, whether or not she operated and/or advertised. Yesterday, an order was entered that said that she did operate and/or advertise without a permit. And now what the court's going to do with that, he entered an order yesterday ordering that violation to stop.
So what was the judge waiting on to make another ruling? And
Well,
when was that?
typically in environmental court, the judge will enter an order saying, it's called a mandatory injunction plus $50 a day, and it's an injunction saying you can't, stop violating this, and there's a $50 a day fine for every day the violation continues. And then he sets it for status to determine if they have come into compliance so that it can go final. Will there be a fine assessed? Will there be further injunctions placed on the property?
In your opinion, what legal effect does that have on us today and what we can do?
Well, again, there are two different issues, and so I think if y'all issue a finding that if y'all determine that she's eligible for a permit, whether that's 6 months from now or a year from now, whenever you determine that she's eligible for a permit, because it's a different issue, that 6 months can run concurrently with any amount of time the environmental court order is put down. So I don't know that you're necessarily barred from making a ruling today. I might.
Even though it's the same property?
Same property, two different issues.
Okay.
So one is y'all are to look at whether or not the permit was properly denied, and then you're allowed a discretion of up to a year if you find that it was properly denied. The environmental court doesn't look at whether or not the permit was properly denied. The environmental court judge looks at whether or not there was a violation, and if there was a violation, there would be the judge would presumably put down a different penalty.
So any of the previous applicant could very well have been in environmental court, had a neighbor or anyone complained to environmental court and said, hey, you're operating without a permit. Instead, his path was, hey, I want to do the right thing. I went to codes, and they said, no, you operated first. So it skipped that process. So this is just where there was an active complaint in environmental court that they violated it, and so it's got to go through that cycle. I mean, it's not necessarily a sign of, to us, as something being a more serious case. Is just a time frame to deal with, or is it, or does it have a heavier weight?
I think that's probably case specific. I mean, I don't know. I don't know the facts around that one. I believe there actually was a warrant filed in environmental court.
I would like to open up the public hearing again and ask the applicant a question.
And before we do that, I'm sorry, I missed the very first part of what you said. Who filed the injunction?
The court ordered an injunction.
But I mean, what brought that action? What started?
Metro filed a warrant that there was because there was a violation. We sent an abate notice. The violation continued. Therefore, we filed a warrant in environmental court asking the court to order her to stop, or order the property owner to stop violating the code.
Was the warrant specific about the violation, as in when the violations had occurred, or just that it had occurred at all?
Well, the warrant says that it occurs, and then at the hearing, that's when the judge determined, here's the evidence. Yeah, the warrant just gets it in court, and then the judge looks at the evidence to determine what the ruling would be.
Okay.
Okay, so the question so what happened in court yesterday?
And yesterday.
Or when was it?
The property owner did not appear in court yesterday.
Oh,
I'm not even aware of what the abate, what you're talking about. The only letter I've received was on February the 20th, which I have a copy of, that told me to come down to Metro. It did mention the $50 fine, and that's where I started to seek out what I need to do to correct it. So I'm a little bit.
Is this the first that you're knowing of this court case that was involving you and this property yesterday?
Yes.
So it was a default judgment, I guess.
It was a default judgment yesterday. We did send the abate notice, and then there was a warrant filed that we received proper service on. And then because, as is the usual, when the defendant does not appear in court, the judge will put down a default order.
What do you mean when you say proper service?
You have to prove that they either certified mail or sheriff actually personally served it. I believe it was sent certified mail, and that's how we got service.
Okay. Any other questions of the applicant? Okay,
I have one.
we're going to close the public hearing.
Okay, can I ask her one more?
Oh, of course, yes.
Sorry. So I just want to be clear on the timeline.
Sure.
When did you apply for the permit?
probably around March the 3rd, somewhere right around there.
And that's when you find out you couldn't get the permit.
I actually had to go back on 2 separate occasions because when I went down the first time, there had been some sort of a meeting, which I have a copy of, where the rules or the guidelines had changed, and there were some additional documents that were required. And so I came down the very next day with those documents, one of those being a certified letter, from my neighbors, authorizing me to do the
Right.
short-term rental, which I did provide.
And so after that, you went to the codes the first time. When did you take down the advertisement and stuff?
I took it down as soon as I went down on March the 3rd the first time, when I
And
inquired
you
about
haven't
the
rented-
letter.
You haven't rented it since that
So
date?
which sites were they on?
Just Airbnb.
So your neighbor, Christy Carr Klein,
I don't know who that
has
is.
submitted 2 links to something called HomeAway.com.
It's not on HomeAway. It's never been on HomeAway.
Okay. I mean, I don't know what
Have you seen this letter?
I haven't.
Do you-
And I don't know who the neighbor is either, so.
I guess the question I have on the environmental court issue is that it sounds like that, according to our Metro attorney, that someone signed a certified letter,
Okay.
and so who signs your mail?
It's me. I mean, I'm single, I live at my home, so
So-
I haven't signed for any certified letter from Metro. So, now I will
Okay.
tell you this, maybe this is linking back, and I have email to support this. I sent this to Debbie Life, what she supports, I think, this court.
Yes.
Oh, you and I have had some email exchanges around this, where somebody had attempted to deliver a certified letter, and I wasn't home. He called me, and I have a copy of that. Do you recall that email exchange, Debbie, at all? I don't know if I'll have to
Okay,
question her, I'm
Mr.
sorry.
Chairman, this is the moment where I would remind the board that our public hearing is closed, that even to the extent it's open,
Well, I think we...
Ms. Lipsey's probably not being
No, we reopened
examined.
it.
However, if the board wants to hear from Ms. Lipsey, it might be appropriate, but probably not interrogated
Yes,
from the
okay.
witness stand.
Okay.
Okay,
And-
so,
But there was something that was supposed to be delivered to me because I had a note. I called the gentleman, he lived up in Hendersonville. He asked me what time would I be back, the next day from work, and I said, well, I typically work business hours. I never was provided anything, though, from,
so to me, this is going round and round and round, and this
Okay.
is what I would recommend, and see if my board members go along with this. I don't know what happened to court. I don't know why you didn't show up, and I don't know about service or anything like that, but we still have this court default judgment hanging out there.
Okay.
And there's also seems to be some unanswered questions that we may or may not be able to get today. I would recommend that we defer this case and you come back
Okay.
and basically clear up whatever with the court, and then also make sure that, look at this letter that we've gotten and these links to HomeAway and, how many other places was it listed or not? And so are you willing to defer this maybe a month?
Sure.
And then come back and not rent it during that period of time too, because, or advertise? Because either way, you've got this court default judgment that you've got to take care of. So even if we ruled in your favor,
Right.
this is still kind of hanging out there. So that is what I would recommend as colleagues. What do you think? Okay.
can I ask a question?
Yes.
Where do I get that letter? I mean, where do I start with this letter?
Codes Department,
I'd talk
Property
to the
Standards
Codes
Division, 3rd floor of the Metro Office Building next door.
Okay.
Okay.
And they'll be able to provide.
So I move that we defer this 1 month. What's the May meeting, John Michael?
Thursday, May the 4th, 2017, 1 p.m., this same room.
Does that work for you to come back here? Okay.
Will I receive something?
Yes, you will.
Okay, all right.
Motion's been made to defer to May 4th, 1 month. It's been properly seconded. Any discussion? Seeing none, all those in favor of deferring this until May 4th signify by saying aye. Aye. Opposed? We will see you back here on May 4th,
All
but in the interim, talk to codes and fix whatever this
Okay.
default judgment was in the environmental court.
All right,
And
thank
make
you.
sure you go to court.
Yes.
Well, I didn't know I needed to be here, or I would have been here, trust me, I would.
Okay, thank you. John Michael.
Mr. Chairman, the next case to be heard is case 2017-086. Because this is an adjoining lot with 2017-087, with the board's permission, we'll present these cases together. So they are owned by the same ownership group, and principal controller of that ownership group. It seems appropriate to present them together. It's an item A appeal of revoked short-term rental permits that had been issued in error. And the sequence of addresses here is 3301, 3303, 3305, and 3307 Albine. They're 33rd over near Tennessee State University. The aerial here shows you the properties, 2 duplexes on adjoining lots. That's 2 lots, 4 residential units. Staff originally made the error of issuing 4 permits to these 4 residential units. That being an error, of course, because the short-term rental property law that changed in January of 2016 mandated that you could only have 1 short-term rental property per lot in R&RS districts. So a duplex could get 1. A triplex, which is treated as multifamily under the Metro Zoning Code, inexplicably, could get 3 permits. However, for single-family, 2-family, whether HPR or traditional duplex, only 1 permit could issue. When staff caught the error, staff issued the revocation letter for the 2 later issued on these 2 specific lots, thus leaving 2 short-term rental permits intact, 2 revoked, and Ms. Sanders timely filed her appeal to this board with regard to the 2 that had been revoked.
So if this were all one piece of property and had 4 units on it, they could have 4?
That is correct.
So
Is there anyone here in opposition to this case?
John Michael, what was the lag between the issue of the permits and then finding out that they were not supposed to be issued or whatever?
I believe those permits were issued in 2016, and then the revocation took place in either February or March of 2017. Forgive me, I don't have the letter in front of me at the moment, but it's somewhat recent.
We'll ask the applicant. Okay. Anything else, John Michael, before we start?
That is the overview. The law says you cannot have more than 1 per lot for these properties, hence the revocation. And the only other thing I would add, Mr. Chair, is typically if you see a revocation from the zoning staff, it is, I shouldn't say typically, it is frequently in response to bad action, bad behavior, failing to live up to the requirements for good operation of a short-term rental property. No insinuation whatsoever that that's the case here. This has been a responsible property owner, a responsible short-term rental operator. However, black letter of the law says this can't be, hence the revocation.
Okay, and to remind the board, this is a case that Council Lady Sharon Hurt spoke upon, and we have the letter from Council Lady Erica Gilmore.
But before we get into this, can we find something that's prohibited? I mean, can we, even if we found it in her favor, can we actually?
That's a very good question. So let's ask our lawyer. So Mr. Harper wants to know, can we find if we found in the favor of the applicant, would the applicant be able to have 4 short-term permits on this very property, or these 2 properties?
Well, I think in order to find in favor, because this is an item A appeal, in order to find in favor of the applicant, you would have to find that the zoning administrator acted in error or arbitrarily. Absent that finding, I don't think you can find in her favor.
But if we did overturn the zoning administrator, would she get to keep these 4 permits? Because it sounds like, if you listen to what John Michael said, is not allowed under Metro law.
Well,
I know what the zoning administrator says.
I think that the law says that she cannot have more than 1 permit per property.
Yeah, so
I'm not sure that y'all have the law, for example, to make.
The zoning administrators who were going to look to see if he was right or wrong, so now I will ask the zoning administrator, basically what Mr. Harper said, or just in general, why did you rule this way? This woman had 4 permits, and then she was told that she could only have 2.
Because the law changed in January of 2016 that would only allow 1 on a lot, 1 short-term rental permit on a lot. So we've got 2 separate lots here, and only with a duplex. So only one of the units on each lot is entitled to a permit under the current iteration of the law.
So in year 2016, this was in compliance and renting out all 4 short-term rentals was legal?
Upon passage of the ordinance in early 2016 that said, and clarified, that's probably the better word, that only one is allowed, even when there are 2 residences on one lot, that was the original issued permit was issued in error. So there was probably never a time when staff should have granted that permit from the date of the application forward. If, however, this had been issued back under the original iteration of the short-term rental ordinance back in 2015, at that time, the law had been changed to make that restriction, and 2 could have legally issued. And in fact, around town, there were a number of properties where 2 were issued.
Okay, well, I'm
A process
confused
that we're
because
still
we
cleaning
said
up.
because of the change of law, this happened. So is that not the case?
But you're saying the law changed
You said the law,
before.
because of the change of law in 2017, this,
No,
was it 16 or 17? 16. So is that what prohibited this from happening, that law, or a later law?
The winter 2016, January or February 2016, and forgive me, I'll run and get you a printout of the exact ordinance. That change in law is what created this restriction that kept 4 permits from issuing legally.
And as was said earlier, Metro, as you said, in error, gave 4 permits for this when, according to Metro, they should have only given 2.
That's correct. And the basis by which these were issued, typically when you see a duplex lot, as all of you know, you'll see 103 Main Street, Unit A, Unit B, 105 Main Street, Unit A, Unit B. However, here, as shown from my site visit photographs, the properties, which is totally appropriate, are individually numbered, 3301, 03, 05, 07. So when staff reviewed, it didn't occur to them this was, in fact, 2 duplex lots sitting side by side, but instead it looked like 4 single-family addresses, hence the issuance of the 4 permits, albeit in error.
So when did they find out, and how did they find out then?
I don't recall how it was brought to our attention, some form of complaint, I would imagine, but nevertheless, we found out in February or March of this year.
Okay. Board members, any other questions of staff before we hear from the applicant? Okay. Please identify yourself for the record and your address, and tell us why the zoning administrator was wrong.
I'm Billy Sanders. I live at 3514 Geneva Circle. I'm the president and sole owner of Sunshine Enterprises, which owns the duplexes at 33rd and Albion. And I guess I would just like to address, if I could, your question about how the zoning administrator found out. It was because I wrote a letter to the council when the ordinance in 2017 was being proposed, because that was the first time I saw that there couldn't be two permits issued on a lot. And I was asking to be grandfathered because I didn't know that that was the case. And I did look up the law. I mean, I looked on the website at the time, and actually, the law that put, the amendment that in 2016 that put 1 permit per lot is actually not identified on the website. It's listed on the website. I wish I could show you if we had the screenshot of the short-term rental permit site of Metro. When you click on that, that amendment does not come up. 909 comes up again. And so I didn't know, so I was asking the council to grandfather it. And somehow, I think someone from the council actually notified codes that I had 4 permits, because I was openly and notoriously saying, I have 4 permits, I want to be grandfathered. And so that's how it was found out.
So what was the lag time? They said that they issued them, and then they said, no, we made a mistake. Tell us about that.
The second permit at 3303 was issued in July 1, 2016. And so it was in February of 2017 that the letter was sent out saying that the permits were revoked. And with respect to the law, I guess I in summary, what I'm seeking that you acknowledge that, one, a permit is no longer required because of the change in the law that occurred from Ordinance BL 2016-492, which was passed became effective on February 24th, 2017, and it deleted Section 6.28030 of the Metropolitan Code entirely, and it amended Section 17.0406 of the Metropolitan Code, and it deleted the current at that time, current definition of short-term rental property, which your handout that I gave you says that a short-term rental property means a residential dwelling unit containing not more than 4 sleeping rooms that is used and are advertised for rent for transient occupancy by guests, as those terms are defined in Section 5.12.01 of the Metropolitan Code. Dwelling units rented to the same occupant for more than 30 continuous days, bed and breakfast establishments, boarding houses, hotels, and motels shall not be considered short-term rentals. The new ordinance created a new definition for short-term rental property, which is now codified in Section 17.04.06, and that definition says a short-term rental property means a residential dwelling unit containing not more than 4 sleeping rooms that is used and are advertised only through an online marketplace for rent for transient occupancy by guests. That word "only" is significant and was intentional, as it was underlined and added as an amendment on third reading of the ordinance. The accommodations that I have provided at the properties in question no longer fall under the definition of short-term rental because the dwellings are not used and are advertised only through an online marketplace for rent for transient occupancy by guests. I use an online marketplace, but I also advertise the property directly to potential guests and to businesses without going through an online marketplace. And I use the accommodations for friends and family who come to town as my personal guest. I also, have copies of emails where I've communicated with businesses regarding the use of these properties on a short-term basis.
Okay, so we're here to determine why the zoning administrator acted in error.
Right.
We understand why and how you market it, but why did Mr. Herbert make a mistake?
Well, the letter that I received was dated March 24th. That was the same day that this new law became effective. And in that letter, they said I was to cease and desist in providing short-term rental services, and I was also subject to prosecution on under Metropolitan law if I continued to do that. Well, I'm saying that's an error because the law changed on February 24th, and the definition of short-term rental changed, so therefore, I no longer need a short-term rental permit to do what I had been doing. But I'm saying, even though that's the case, I want you to reissue my short-term rental permits.
How do you not need a short-term rental permit? Because I thought our new law and even our original law prior to after 2015, short-term, any rental under 31 days is regulated by this law.
Well, there's a new law that was passed February 24th, 2017, and that's the one that I'm speaking of, that changed the definition of short-term rental. And short-term rental is now a property that is used and advertised only through an online marketplace. I have a copy of the whole ordinance if you would like to see it, but it was amended on third reading. If you'll notice the footnote in my handout that I gave you, where it says when that law was proposed, the word "only" was not in the definition, and on third reading they amended it and put "only" on there. So that takes a lot of properties out of the current definition of short-term rental. If you don't just do online marketing, you're not a short-term rental anymore, and that's what I'm saying. The zoning administrator erred because on the day that they sent me the letter saying they were revoking my permits and that I was in violation of the law, I was no longer, if I had been in violation of the law, I was no longer in violation of the law on February 24th.
Okay.
And with that, even though I I contend that I do not need a short-term rental permit. I want you to reissue them because the law in Nashville is in a state of flux. There are still 3 ordinances pending before the Metro Council regarding short-term rental permits. So they could change the definition again tomorrow, and they could also change something else that would require me to have a permit. So I want to have a permit so that I will be grandfathered if there's something new that happens that requires me to have a permit. And I also want to have a permit if later I need a permit, there may not be any permits available in my census tract because there's a limited number of permits that you can get in the census tract. I was the first entity to have a permit in my census tract, and I was the first 4 permits in that census tract. So I feel like I will be terribly disadvantaged if at some later point I won't be able to get a permit when I need one. And in terms of the era, I believe that law is arbitrary. There's no rational basis for prohibiting a 2-dwelling unit not to have multiple permits when a triplex can have 3 permits on one lot. A multi-family apartment complex can have multiple permits on one lot. I listened to the council meeting record on January 19, 2016, when that 2016 amendment was introduced to to limit 1 permit per lot, and there was no rational reason given. There was some talk by the sponsor that there had been parties in some areas that were a problem, but that's still not a reason to have 1 permit per lot. So I contend that ordinance is arbitrary. Therefore, any decision made under that ordinance is arbitrary, because if you saw my property up there, I can have alternating a long-term tenant, a short-term tenant, long-term tenant, a short-term tenant. But I can't put the short-term tenants together and the long-term tenants together. And to me, that's just arbitrary. I mean, if there's going to be a disturbance on that piece of property, it's going to disturb everybody probably. So it just doesn't make sense. And I haven't had any problem. I have several neighbors here who are in the audience who will speak in my favor. I have letters from neighbors who are in support of this.
Any other neighbors wish to speak to the meeting today, or has she said it all? Come up here for the record and sit down and identify yourself if you wish to speak.
Thank you.
Press the button, please. Yes.
Good afternoon, ladies and gentlemen of the panel. I am George Thompson. I am a long-term resident of the community. And if you would go back to the overhead view of that property, which was a vacant lot, that property was a vacant lot, and you can see the vacant lot that's adjacent to that from the overhead view. And it was nothing but overgrowth, whatnot. And it was really a distraction to the neighborhood until Sunshine Properties Incorporated developed the property. I see that property as being a credit and something that has brought the community up rather than distracting, and I certainly think Ms. Sanders has made a strong argument. Well, if you can't do it for 1, why can you do it for 3 and 4? I'm not in a position to argue that, but I'm really here to say that that property has been a benefit to the community rather than a distraction. And I would ask you to really give it serious consideration. And of course, the legal argument that she's made, certainly, in my opinion, I too am a lawyer, gives this board the authority, if what she says is true, to not only issue the permit or to or to take back the revocation that was previously made. I strongly support Ms. Sanders' appeal to the board and ask you to give it every appropriate consideration.
Okay, we have 2 minutes, 45 seconds left. Anyone else wish to speak, or Ms. Sanders, you can conclude?
Mr. Dixon is here.
Mr. Dixon, please come forward. Two former school board members.
I too have been a lifelong resident in that area, and I just came today just to be supportive of this particular project, simply because this is a property owner that is also concerned about the community, and with the changing demographics that are taking place. I just have confidence in her in making the right kind of decisions and allowing the right people that are in that. It's unfortunate that a mistake was made, but I think that it was probably made from the standpoint that it did grant and give an opportunity for an owner that I think is deeply rooted in the community and values what happens in that community. So I just want to be supportive of her.
Okay.
And that's V.H. Dixon Jr.
Thank you.
Property that I am at is 3309 Claire.
Thank you, Mr. Dixon. Anyone else wish to speak on behalf of this applicant? Ms. Sanders, you have 1 minute and 41 seconds to conclude.
I would like to mention that I have several letters from community members, including the president of the Neighborhood Association, the College Hill Neighborhood Association, who is in support of this. I'm also a member and one of the people who helps establish that Neighborhood Association and serve as co-chair of the Community Development Committee. I've lived in this community for over 39 years, and I live 3 blocks from the property. I pass by it all the time. I have rules under my short-term rental permit that people cannot have parties and that they are to be respectful of the neighbors, and I pass by there enough to know what's going on at the property. So I am seeking to be a responsible landlord, and I believe because of the inequity that resulted from the errors in the codes department in issuing these permits upon which I relied, I'm respectfully requesting that you allow these permits to be reissued, and also, acknowledge, even though you would allow them to be reissued, that they're not needed under this new law.
Forgive me if this has already been gone over, because we hear this a lot. And by the way, I'm really appreciative of your presentation and the position you're taking. I'm every time I look at our docket and I see 4 or 5 STRP cases, I'm just like, what on earth are we going to talk about? And this is new. This happens every now and then, and it's very very intriguing. So once you received notice that they were revoking the 2 permits, have you rented or advertised?
I blocked the site.
Okay. I just wanted to have that on the record because I didn't know if we've actually talked about it. But thank you for your presentation.
Thank you.
Any questions for the applicant? Do you have anything else to add, Ms. Sanders?
I know this is an unusual situation, but I think, equity, I hope that you will see that equity, would require, or at least, you to consider, what is happening in this situation. I pay my hotel, motel taxes. I've tried to be a responsible owner, and my neighbors are in support of this.
I'm sorry.
And the councilman, I have 2 councilmen at large, as well as my district councilman, who have been in support of this.
Are you an attorney also?
Yes.
Oh, okay. I want to get your opinion on this. I'm going to ask our counsel also, but you've brought up equity. I've said this, and sometimes I'm not a lawyer, so you have to take my questions with a grain of salt, but do you think this board is to consider equity in these matters? It sounds like you do think that.
I do. I think that's why we have citizens boards, because you are citizens of Nashville. You do this on a volunteer basis, and I think that's the check and balance that we have with, with having staff and so forth. And I understand it's difficult. I'm not trying to criticize, the staff. I'm just saying that's why we have citizens boards, so that you can deal with unintended consequences of things like this.
And I'll ask another question about the legal, about your legal opinion on this, and that is if we were to disagree with the argument that the code changed and that applied, just say, that, we got advice that said, no, that argument doesn't hold. Are there other avenues that you see, from any legal research that you've done, or, equity-based or grandfathering, anything that would say, no, here's, if you don't agree with this one, here's how we can support your position?
No, you're saying if you don't agree that the 492 changed the definition?
Yes, ma'am. I'm just saying that, and I'm not expressing my opinion on it because I think it's very complicated, and I know when we stop asking you questions, we're going to turn this direction and ask, our legal counsel a lot of questions, because it is the first one we've heard, and certainly I will say I would be eager to find a path on this one. It's one of those cases, it feels like to me, just expressing my personal opinion, it feels like to me it is not a fair situation, but yet I understand.
I think what he's asking is, do you have any legal kind of precedent or law that says, even if we don't buy your equity argument, you're grandfathered because you did this before and this changed later? You had 4 units before, then Metro changes this law saying only 1 unit per lot. That's what I think he's trying to get at.
Yeah, I'm just trying to say is there another angle that we could consider if the first angle were, not going your way?
Because, and we're not deliberating, but, I might get the impression if I was sitting over there, even if we overturn the zoning administrator, if the law says that you can only have 1 per lot, I'm not sure if we are able to give that, right? But if you say you're grandfathered, that's another argument.
Well, the sponsor of the bill, I believe it was 215, the 2006 amendment that initially put in one permit per lot. I listened to the council meeting when that was introduced, and she did say that those who already had 2 permits per lot would be grandfathered. And so I'm asking also to be grandfathered, although I acknowledge my permit was issued after that time. But because of the mistakes that were made, that were, not,
we just, I think, looked at the actual law, and as you know, in debate, certain things get said, but when it comes down to passing the ordinance, what's in the ordinance is in the ordinance, right?
Mr. Chairman, on behalf of staff, an important clarification. The ordinance that changed, and I think we've got a copy circulating in front of the staff now, the January 2016 version. Mr. Harper, if you have that, what was the bill number again?
BL 2015-94.
So bill number 94 that took effect in January, February of 2016 The grandfathering language that was discussed meant that the people who had already received those permits would be allowed to continue under those permits. Nobody went out and tried to stop them the very next day as far as the second permit issued on a duplex lot. And I thought that was an important move and a good clarification by the sponsor of that bill. Otherwise, folks, like at the time, Ms. Sanders, who had her two units there with duplex permits, they would have come knocking the next day, theoretically, with whatever theoretical staff was available to go door knocking, to take away those second permits. However, those are one-year permits, and those have been treated by the legal department and by the codes department alike as business permits that one cannot grandfather into. They're not land use questions, they're business permit questions. So the idea of allowing someone to continue until the expiration of the one-year permit was what was in play.
Is that what the law says? Because to me,
The law doesn't say any of that. It also doesn't say grandfathered in the law.
Well, it's my understanding those permits were grandfathered, and I acknowledge I did not have a permit at that time.
Yeah.
But that, I would expect them to have been grandfathered and been eligible for renewals.
Okay.
So,
But, I will say, again, because of the law in 2017, I don't need a short-term rental permit because of that definition. But I know, and you know, that there are 3 bills pending in the council. That could change. There's 6. So, it could change. And I don't want to be left without the opportunity to get a permit because I have relied, I have entered into contracts. I have, furnished these apartments. And I did everything that I felt I was supposed to do in order to get permits before I began operations. And it happened not only once, it happened twice. And, as you can see on the screen, it's clear they were duplexes,
Sure.
because they look at the plans, I assume, when they issue the permits.
Right. Any other questions of the applicant before we close the public hearing?
I want to commend you for bringing us something that's absolutely unreal. Thank you.
Okay. Anything else to add, Ms. Sanders?
All I can say is I would just, I'm laying myself on your mercy because, I was just shocked and stunned. This has been really very upset. I've lost a lot of sleep over this. I really have.
Okay, thank you. We're going to close the public hearing.
so we have this I usually am very careful when I say the word complicated and complex. So to me, they mean two very different things, but I think this definitely falls under complicated, and obviously the appellant
Yeah,
is.
this could be a question on the Tennessee bar exam.
So I guess the main question I have for our legal counsel is to help us think through the argument that of the language of the definition, because it does seem, it seems like it would quickly be changed by council if it were determined that this were the correct way to look at it, but it also seems very clear, and by underlining the word only, they're underlining apparently that that's what they meant. So, what was your take on the definition issue and the definition argument?
I think she makes a good argument. The definitions, it says only, it's advertised only through, it says it's a residential dwelling unit containing not more than 4 sleeping rooms that is used and/or advertised only through an online marketplace. So I think if you look at the advertising element, if it's advertised only through an online marketplace, that's what they intended. However, it does also say used and/or. So if it's used outside of advertising, on a short-term basis, outside of advertising, only on an online, you've got to look at the used and you've got to look at advertised.
Just to play devil's advocate for a second, so if within that argument we accept the fact that it does not fit the definition of STRP because it was advertised somewhere other than only online, then And since somebody could take out one ad in the Scene or something and say, hey, I'm exempt from this law now because I've also advertised it in print and not just online, or I've told 3 people
Or they
about
could put it on Twitter, which is not advertising.
but it's online.
Well, again, I think that, as was said earlier, the council could clean this up if they wanted to, quickly, if they wanted to. And yes, I think you are also correct, Mr. Harper, that if they advertise in ways outside of an online marketplace, perhaps they don't meet the def element of advertising. But again, I think you have to look at the definition, which says used and/or advertised.
So educate a non-lawyer for a second. I understand there's a principle in law about when there's something in a contract or a law that is contradictory or confusing is probably not the right. Let's just say contradictory. Who then does that benefit, or is that just with contracts, or it doesn't count with law? If a law is contradictory, and if we found that the ordinance was contradictory to itself.
I mean, I think if you find that a law is ambiguous, you could look at the legislative intent behind it, which would require going back and watching the council meetings and seeing what the actual intent was. Outside of any ambiguity, I think you look at the plain language of the law, and the plain language of the law says a residential dwelling unit used and/or advertised. So I don't think that you can use it only through an online marketplace. So I think that only through an online marketplace modifies advertised. And so you've got the advertised element of a STRP, and you've got the use of the STRP.
The way that this is drafted, you could even argue used and advertising used through online. It's just very ambiguous the way that this language.
I think it contemplates multiple scenarios because it says used and/or. So
I
I
know,
think
but used through finding it online, to me, I mean, they could have been a whole lot clearer if they just wanted to say just used period, right? That's not very clear the way this is written.
And Mr. Chairman, on behalf of staff, as you will be determining whether or not staff erred in revoking these permits, our interpretation of that section of law is not that merely providing some form of advertising other than an online marketplace, i.e. standing up at a neighborhood cookout and announcing, I have a short-term rental, is enough to take away the completely overwrought present necessity to have a permit for a short-term rental operation. That is not how we have interpreted it. So if you disagree with our interpretation, then the appropriate move would be to approve the appeal, we admit.
So let's hear from the zoning administrator. And so how'd you come up with this and why?
So, get the language. Yeah. So I think that Ms. Sanders makes a point. I think she does when it talks about only through an online marketplace. We're looking at the word used and as somewhat separate from advertising, and we were attaching the advertising portion only through an online marketplace as one part, one way that you could be a short-term rental, the other way being used as a short-term rental. So that was our interpretation of it. Granted, it's a little bit ambiguous.
Is there a question to change this subject just slightly? If we didn't go down this potentially kind of precedent-setting interpretation of this rule, is there a remedy based on, there's such a long time. I mean, the first offense happened 3 months after the rule that went into effect that denied it. I mean, there was a duplex. The first one got rented. 3 months later, the second unit of that building got rented. And then 3 months after that, a full 6 months after the law passed, the other two were rented simultaneously. And at that point, it seems to me, if I were the homeowner, very clear that I was one, doing the right thing, and everything was fine, and I could invest, furnishings for, 2 full units and spend a lot of money. And I remember in previous cases, the concept of a property owner or homeowner kind of having to go through all that expense and everything would warrant a remedy. And I don't know if we ever decided that way, or I know the concept has been presented by, some of our prominent attorneys that come here that, in a different case. So I know that argument's out there. So
you're talking about equitable estoppel, and I'll let Ms. Lamb explain that. The general principle is that there is the potential for equity to be applied. Generally, that principle does not apply against a governmental entity. So taking a step back on these properties, while the second permit for each lot should not have been issued, in defense of my department and staff, we get a floor plan that shows the internal workings of any individual unit. I don't know what the floor plan showed on this one, but generally it's only the unit in question, that which the fire marshal is going to go in and look at, is to designate where smoke detectors are supposed to be and where the windows are in that unit and all of that. So unless it was disclosed to us openly that it was a duplex, that there were 2 on one lot, in fairness to staff, there's not much way they could know that without perhaps pulling up some aerial photography and looking, because we've got individual addresses. We don't have A and B units. We've got a floor plan that probably shows only the interior of the unit that is to permit it. There's really no way that they can know that without perhaps going to aerial photography. Could they have done that? Yes, they could. But with the amount of short-term rental permits that are being issued daily, to ask them to go through that analysis on every one is quite frankly kind of a tall order. So while the permit should not have been issued in the first place, in defense of staff, I totally get how this happened, and it's indeed it's regretful. It really is. But this is a bit of a unique situation. I think that Ms. Sanders has got a point. I mean, I think she does. I think she's got a point that the language that she's talking. But it sounds to me like but she wants the short-term rental permit no matter what. So I think she could make the argument that I'm not a short-term rental. I can keep on going on anyway, fine. But if she wants a short-term rental permit, then it kicks it back into you all's purview here. And did staff err in issuing the permit or revoking the permit? I think we erred in issuing the permit, even though I totally get how that happened. So we don't take offense if you think, for any reason, from equity or otherwise, generally speaking, equitable estoppel does not apply to governmental entities. But we don't. This is an unusual case. Clearly, it's clearly an exceptional circumstance.
Mr. Herbert, so what happens if we do find that you erred? I mean, can you issue the permits, or do you have to? What do you have to do?
So the ordinance says only 1 per lot. That's what it says. This board grants variances. That's the authority that you're given by state law. And if this board tells us that we should issue it, that you find equity there, and we should issue it, we're going to honor that. Yeah. We're going to do what this board tells us to do.
And the reason I would feel more comfortable if that is the will of this board is this is a census lot that is not completely full as far as I know, or not like some of these other areas of town.
I guess so you're saying if we said the zoning administrator didn't err, but there was.
I think if we're going to get real short-term permits, we're going to have to say he erred. if they're going to get 4 permits for this, I think the only way, and I could be wrong, that they're going to issue 4 permits is to say they erred.
We have to, I guess what I'm saying is if you said you didn't, but we have the authority to, the variance authority, could that be part of that to say, no, that, you know, you can't have 2 lots and there were 2 lots, but because of the way it happened and, I don't know, I'm just, it doesn't sound like that's a path.
Let me ask you this. Permits are issued for 1 year, am I correct?
Correct.
So after 1 year, they would then have to comply with the law, correct?
Correct, and that's, well, when we find duplex units, and there was a period in time before the 1 short-term rental permit per lot was in effect, when 2 permits were being issued per lot. Council didn't like that and changed the law. When those permits then came up for renewal, we had to not renew 1 of them because only 1 is allowed per lot, and that's what we've done.
Right, I
And
understand that.
I think that, just to elaborate, I think that goes to the grandfathering issue that has been brought up. By the nature of the permits having an expiration date, it was not contemplated that they would be grandfathered indefinitely. If the law changes over the course of the year, they would be grandfathered for the duration of the permit until it expires. After it expires, it would have to be reissued or renewed. It doesn't go on forever, it expires. So I think that's why when there were 2 on 1 lot before this law passed, once 1 of them expired, it could no longer be renewed. It was not, it had been grandfathered until the expiration date, at which point they had to apply for a new permit, and Codes was precluded from issuing that permit because the law now said they could not do so.
So when does this current permit expire?
That I don't know, but just to correct something, if you've got a short-term rental permit, they expire on a yearly basis. We notify you that you need to re-up your permit. So we don't issue new permits, the other permit, but it has to be re-upped on an annual basis. But there is no grandfathering.
Say that if you erred and issued 4 today, they couldn't renew those 4 a year from now?
Correct.
Even though they currently have 4? A year from now, it'll only be 2 that they're able to?
And if the ordinance doesn't change and we make that finding, then aren't we saying that she essentially can come back and make the very same appeal, and we would have to find the very same thing a year from now?
Well, but it also, I mean, you know, I mean, to me, I think, you know, that part seems very clear, and, you know, I would think that there are, you know, other remedies too. I mean, you know, earlier at the very beginning of this hearing, we said, you know, if it were a triplex, or if it were all 1 piece of property, and there may be, you know, ways that, I mean, it's not my property, it's not my choice, but, you know, if the homeowner had a path to say, well, I will go to the planning commission, try to combine them, then it's a quadruplex, and it might take a year to do that, but I can keep doing what I'm doing. You know, I mean, to me, there's an equity part that I would like to achieve if possible. Again, you got rules and laws and stuff that we have to follow, and sometimes you just can't. You know, you wanted, I mean, there are plenty of cases where we felt like the fair thing wasn't what we could or had to do that day because it's just the rules we have. But to me, that's what I'm searching for. Is there a temporary solution that allows the homeowner time to either work with council, wait for the 6 bills to make their way through or not, so that the new rules may or may not apply, or go through another option?
I think the way to do that, I think, is to find the administrator erred and, you know, start that calendar rolling. And I mean, we heard from either directly or indirectly 2 or 3 council persons on this very specific case. So either action's going to, because I don't think anyone's going to, well, I don't know about the appellant, but I'm getting the sense that Metro is not going to appeal our decision if we find that he erred. So I think the only real remedy will be legislatively, and I think it will pretty much end here. So I think your solution can be found in finding that the administrator erred.
I disagree. I think the key for her would be if she were granted the permit now to continue until it expired. What does it be, 1 year from now or 6 months from now, whatever? Then it's going to change. Then she has to comply with the law, because there's no talk about grandfathering.
I'm saying, and maybe I misunderstood what Mr. Taylor was saying, but I believe we should find that the administrator erred, and to me, she would then get the permit. We would be ordering, in essence, depending on the motion, that the two absent, or the two revocations either be restored either from the date they were revoked or from today. But either way, she would have about a year to let this work out, and then it's, someone's got to find a solution, but we can only address this until the end of the permit. Right? Is how I'm seeing this. So, and I'll make a motion to that effect if anybody
Okay,
wants it.
what's your motion?
I move that we find that the zoning administrator did err in revoking the two permits, and that we find that the permit should be reinstated.
The 4 permits.
Well, only 2 of them revoked, correct?
But I guess all 4 should be in place.
Yes. Okay. Well, and to be clear, that all 4 should be included.
Okay, there's a motion. Is there a second on that motion?
I'll second it.
And what else did you say?
I just wanted to run that by our legal folks to see if that motion makes, if it holds the water.
Okay, motion's been made, properly second, discussion, legal.
Is there a specific question for me?
Well, my
I'm sorry.
question was, is there need to be a basis?
Do we need to have?
He said the zoning administrator
Why he
erred,
erred?
but didn't, yeah. But
Yeah.
why did he err?
I would amend my motion then to say that giving the arbitrary, is arbitrary the word I want to use? That he erred because of the arbitrary nature of the ordinance, the arbitrary wording of the ordinance.
Okay.
You accept that?
Is that
I
acceptable?
accept that, yes.
Okay, more discussion. Is there any other discussion? Seeing no other discussion?
I guess the only question I have, and I want an answer, but I don't want to get us into a precedent. I don't want us to be regretful one way or the other. I don't want us to frankly regret the situation not being remedied, but I don't want to regret the next case that comes.
Well, I think
I
think at least 2 people, maybe 3 people said that this was a very unique case as far as short-term rentals, and we had not seen anything like this before. And I really just don't think there are too many people that have 4 short-term rentals in a row on 2 duplex lots, so I just don't see a lot of these kind of cases coming up.
And just to tidy up more, I would ask, do I need to specify, or would it be preferable if we specify if we're removing the revocation back to the original date, or
right. So
is that effective today?
Well, I think, probably today. And this board orders the zoning, the codes department to issue, or to have all 4 on these 2 pieces of property.
I'll
Effective today.
Effective today.
I'll accept that amendment.
I think that the permits are good for a year from when they were granted. So I think that if you find that the zoning administrator acted in error or arbitrarily in revoking them, I think the permits are valid until they originally expired. I don't think that this board has the authority to extend the expiration date beyond the original.
Well, then we're just kind of running, so 2 of the permits expire on one time and 2 of the permits expire on another time. That's just what it is. Is that what you're saying?
I think that's the council passed legislation that said when something expires, you can't issue another permit on that same lot. 2 on one lot.
So we're really not making much difference by making this motion. I don't know the dates they expire, but
I don't know the dates either.
Well, then,
Let me ask our applicant, when do these expire?
Let's see. The permit on 3301, which is not, the one that was revoked, expires on February 23rd, 2018. The permit on 3303 expires July 1, 2016, and the permits, 17, I'm sorry, and the permits on 3305 and 3307 expire on September 26, 2017.
So how do we get 3 different expiration dates?
Because they were issued at different times. I first got the permit on 3301, and then I didn't start operating until I had, the permit, and I had a long-term tenant in there. When their lease expired, then I turned that one into a short-term rental. Then the next lease is expired.
so which two got revoked?
3303, which expires July 1, 2016, and 3307, which expires, 17, and 3307, which expires September 26, 2017.
Yeah, the dates are going to be weird anyway, no matter, so if we can't reset all of them, they're all going to have.
Okay. So your original motion that you seconded was for today, so how, are you going to change that, or?
Could
Is that
I make,
acceptable?
Does it matter? I mean, if we don't have
is it okay if I
authority.
make a comment?
I'll let the applicant make another comment.
Well, I would, if you would be willing to like it to, start for the date that they're reissued, because at least that would give me enough time, hopefully, for these bills to go through council, and I'd know really
So what
what
does
the
that
law
mean?
was going to be.
The date to be reissued, what does that mean?
That would be like if I applied tomorrow for a new permit, if you rule in that regard, then that permit would begin.
Yeah,
Okay, that's what
I think I'll leave that in the motion, and if
Okay, thank you. We're
if
gonna
someone
close the
wants to
public
appeal
hearing.
that or
Okay.
question it, they can, but I think administratively.
So how does it stand? What's the motion now?
The two, in summary, the two that were revoked, we are saying issue them effective today.
By effective, do you mean today being the start date for the one-year permit? Or a
Yes.
continuation from the original issue date?
The start date, since they were revoked.
Yes, since they were revoked. Yeah, let's do that. Let's do, because they were revoked at the same time, were they not?
They were.
So.
Let's do it from
since
the
they
date of
were revoked,
revocation.
okay.
Okay, from the date of revocation, are you okay with that amendment?
Yes.
Okay. I
And
think that's the best we can do.
A one-year permit from February whatever it was, 24th or whatever.
Yes.
Okay. We have a motion. Any more discussion on the motion? Seeing none. All those in favor signify by saying aye. Aye. Opposed?
Opposed. I don't think he erred.
Okay. It passes 5-1, and you will be eligible to get the 2 permits that were revoked, and please talk to the codes department about that.
Thank you very much.
And
I
please
appreciate
talk to your council people about fixing this, because it is very confusing.
Thank you so much.
Thank you.
Can you take a break?
John Michael, there's been a request to take a break.
Take a brief break and then come back with our final case of the day.
Okay? Yeah.
Rear setback requirements of the RS20 zoning district for the property located at 5112 Overton Road in the beautiful and charming Creve Hall neighborhood, one of the unknown jewels for the city of Nashville. The project is for a 900 square foot addition to the residential single-family unit. Shown here, this is actually the best aerial I could provide for you, members of the board, to give a sense of the layout of the subject property here at the intersection of Overton and Landon. The site plan submitted demonstrates the proximity for the proposed addition to the setbacks as shown on the screen here. And from my recent site visit to the subject property with the signage properly placed shows the general area where the addition would go. Is there anyone here in opposition to case number 2017-089? Seeing none, the appellant will be invited forward to make the desired presentation to the board. Please introduce yourself by name and address. You'll have 10 minutes to make the desired presentation.
Good afternoon, ladies and gentlemen. Thank you for hearing my variance request. I am Billy McLaren, owner of the property at 5112 Overton Road. It's my primary and only residence. I've been there since 2011, and because of growing family needs and myself being a musician and needing a studio to work out of close to Nashville, I spoke with one of the most respected architects in the neighborhood, Joshua Fikes, and through much research found one of the more respected contractors, Mr. Lewis Roberts, and we both got together on numerous occasions at the lot and kind of collaborated and found that this was the best the best decision going forward in an addition, given the fact that there is a 10-foot utility easement in the back and a 20-foot rear setback and a 25-foot side setback. As you can see, there's not much we can do, and because of those hardships, we came to the conclusion that either way we went, we are going to violate some sort of a setback. So we thought this was the best and would keep with the general nice feel of Creve Hall and would be cohesive with the neighborhood. So that's what you see in front of you. That's what we've come out with, and that's what my variance request is.
You talk to your adjacent neighbor? I mean, is there any opposition to the neighbor that, you're on a corner, so corner lots are weird to know which is the front and which is the side.
Yeah, I mean, if you're going off of the address,
the Landon Drive neighbor.
I don't know them all that well. Actually, I see them periodically. I haven't had any verbal opposition. I know my neighbor to the west, David Mercer, and my neighbors across the street on either side have no opposition to it. I've spoke with them, and they said it would be a good idea.
Okay, and so looking in this, I just want to get a sense for here. That white car, does that go to your house?
Yes, that basically.
What is that little blue shed? Is that your shed? The end of that driveway, is that your driveway?
Yes, basically where you just had an arrow. No, that's yeah, right there. That is where the old garage used to be. So to the other side of that white truck is a fence. Yeah, so you see it right there where that's actually a blue car. That's
okay.
So basically the addition would come out 6, where you see that white. That's
okay.
correct right there.
The house there now?
Yeah, that's the house. That's that blue house. Will you go back to the previous? No, that one.
If you were to move the addition on the site so that you were compliant, would you be tearing down any mature trees or?
No, any trees, like any addition we would add,
No, I
that's
think
what
what she's saying, if you put it on a different location, would putting it on a different location tear down some mature trees?
Are you putting it where you're putting it to keep from tearing down trees?
no. There were a couple, see the big trees in the back, those aren't there anymore. I removed them last year because they were in danger of falling on my house. So there are no trees in question.
We have to find a hardship to grant these types of variances. So what are you seeing the variances, or I'm sorry, the hardship?
You talked about a rear easement. Tell us about that.
Yeah, so if you go back to the survey, now it shows that a utility easement of 10 feet. Now, that's the utility easement, that's not the rear setback, because since the address is 5112 Overton, technically, the rear of the house is, where you see that line where the woodshed, the woodshed's not it's a separate addition, so it's not violating, but pretty much where you see that box right there, if we went out, if that side, if I wasn't violating the side, I would have to violate the rear even more, and it would be into the utility. You can't go into a utility easement, but a 20-foot rear setback really eliminates, really anything that I can do. If you stack those things, like where you see concrete patio right there, you lose your entire rear entrance, and then you're also violating the other side setback. So, given the fact that anything, that, like I said, there's really no way that we could add on and not violate a setback. So it's sort of, picking which setback is to violate, try to find a happy medium. We're slightly violating the side setback and then slightly violating the rear setback while also keeping with the general feel of the neighborhood.
Well, and I do have to say, as I'm looking at this more closely, I was looking at the 9 foot 6 inch variance to the property line, and was thinking, man, that's a little close to the street, but then I saw in much bigger letters that I didn't
Yeah, that
see,
looks,
that you're still
yeah.
25 feet from the street, which is, on some properties, you don't have that luxury, and the property line is at the street, and so to really get a sense of how far this is from the street, you're saying 25 feet is how far the corner would be.
Yeah, if you, like from the survey map, it looks a little confusing. The dotted line is not the street on the side. Where it curves out at the little entrance there at the bottom right-hand side, that's the entrance to my driveway. So it is 25 feet from the street.
And what's in the new addition? Did you say a recording studio?
Well, it's mainly, it's a master suite, because with these smaller homes, we're basically, my studio now is in the old master, and it's in the old master, and we're living, we are sleeping inside of a den, basically, that doesn't have a closet. So we're building this master on, now that we're having a second child. The old music room will be the new second children's room, and then we'll have an actual master bedroom that has like a closet, because that's, people want closets. And then attached to that is a studio that I can work out of.
Is the studio on the side or the back?
Where you see that, pretty much if you drew, how it looks like on that proposed addition, it looks like two boxes. The box that is the furthest, the closest to Overton would be our master, and then the more setback box that would be closer to the utility easement would be the studio.
Any other questions of the applicant? Do you have anything else to add?
That's it.
Okay, we're going to close the public hearing and discussion.
I do think it's unusual to have corner houses actually face the corner. And that does make this property a little unique to others that we see on corner lots. And if you envision kind of squaring it to face Overton, you would have a whole different story. It might not encroach the property. I also was encouraged after reading correctly, in more detail the plan, to say, no, it's 25 feet from the street, not 10, which doesn't seem to be as big of an imposition.
Okay. So you have a motion to make. Any motions?
Okay, I'll make a motion. If there's no further discussion,
There's not?
I'll make a motion that we grant the variance based upon the fact that this is a corner lot and the manner in which the existing dwelling is located, and I would say that as to both the rear and the side variance.
Okay, motion's been made. Is there a second? Yes, there's motion's been made and properly seconded, by the way. Excellent motion. Any more discussion? Seeing none, those in favor signify by saying aye. Aye. Opposed? Oh, okay. It passes 4-2. 5-2. 2 dissenting votes on that side of the room. No wonder no one wanted to make a motion over there. Okay, so John Michael, we have a motion.
And yes, just to tidy up that last case, Mr. Chairman, the motion passes 4-2. The appellant will be able to come apply for, 5-2. And the appellant will be able to come forward to apply for the permit as early as tomorrow at the Metro Codes Department. And then, Mr. Chairman, as you noted, there is one other piece of business for the board.
Thank you.
The board has a motion for rehearing from case 2017-021 that has been filed and suggested it should be brought today for the board. Is the applicant or the movant, Mr. Atofe, present? As he is not, staff would respectfully recommend denying the motion that has been put to the board. He is not here, has not been.
Then let's move to deny this motion for rehearing. Is there a second?
Yeah, I'll second. I'd just like to say, too, we didn't hear any testimony, but based on the letter they sent, it seems like they do have a different enough plan. If they wanted to reapply and have us hear it, it is different enough, and I think that would
Okay, well, giving that, if we deny it versus just let them come back, have we had any communication with them?
I think the motion, to rehear it says that there has to be something that we weren't told, and so they're not here to testify. What they submitted was not new information.
Right.
Was not something that, so I don't think there's a reason to grant this rehearing, but I just want it to be on record that based on what they did submit, they might very well have a case to come back and say, hey, I've got a new plan for the property.
So we've had a motion to deny it, and it's been seconded, right, Mr. King? Any other discussion? Seeing none, all those in favor of the motion to deny the rehearing signify by saying aye. Aye. Opposed? Passes unanimously.
That concludes the board's business, Mr. Chairman.
Thank you.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.